Welcome to Probate Problems and Practical Solutions.
Welcome back to Probate Problems and Practical Solutions with Carly Whiteside, owner of Copper Ren Law in Mesa, Arizona. Copper Ren Law focuses on probate litigation, guardianship, conservatorship, and trust administration across the state. I'm LeAnn Lyon, and today Carly uncovers who can contest a will in Arizona and why. Hi, Carly. How are you?
I'm good. How are you this morning?
So, Carly, how often do you see wills contested in Arizona, and what are the most common reasons it happens?
I would say part of my practice is litigation, a lot of it. So we see a lot of the will contesting, but I think overall, maybe I would say 20 to 30% of wills are actually contested. A lot of people talk about contesting them, but when it comes down to actually doing it, that's a whole other ball of wax. It takes time, it takes money. You've got to have a foot in the door. And I have found a lot of people that approach us about contesting a will. It's because they don't like the contents. It's not necessarily the validity, maybe the person who created its capacity. They don't have any of those concerns. They just feel like, hey, I don't think this is what this person would have done. And then also, like we've talked about on previous episodes, sometimes there's a timing element to it. Of course, if it was done close to the time of death, we always want to take an extra look at that. The attorneys like to drill down and make sure everything was done right, but it's not uncommon for people to kind of make changes last minute when they've maybe been given a diagnosis, they've been given, an approximate time. People really start to reflect and think, and we've seen some changes happen. So that's kind of what we've seen here.
So, how does contesting a will automatically enforce an estate out of informal probate and into the much more expensive formal probate process?
So, whenever we're contesting any kind of testamentary document, a will, a trust, that's, part of the court record, we have something open. Informal appointment, as we've discussed, is where there's no judge involved. Somebody gets appointed based on informal documentation. A specialized clerk makes a decision regarding this of, hey, everything looks fine. If someone comes in after somebody's already informally been appointed, the estate continues to be probated, but now we're looking at litigation, which I've spoken about in a previous episode, what probate litigation is, the steps. And so it doesn't necessarily make it go formal. The only difference between an informal probate and a formal probate in Arizona is the beginning steps. Either in a formal, you see a judge, informal, you don't see a judge. So there's a little bit of confusion. People assume that formal probate means that the court is watching every single thing a person's doing from when they get appointed all the way to the end. And that's not necessarily true. There are checkpoints in the statute, which again, I've talked about with an inventory accounting, that the probate court administration will audit the file and say, okay, the inventory was due on this day. It looks like we have that filed in. We're good. So it's more checking that. It's not necessarily oversight for the actual appointed personal representative. That would be a supervised administration. And so whenever you contest a will, it just becomes expensive because now we're in litigation and we're fighting about it.
That makes sense. And you mentioned one of the main reasons people do contest is that they're not happy with the will. So if a child is left out of a current will but was in a previous version, what specific evidence is needed to prove their standing to challenge the new document?
So that's definitely more of an attorney question. It can be very specific to the matter. It's kind of a case by case basis. I will just kind of talk in generalities here for a minute. Um, what we want to look at, as we've discussed previously, is timing. We want to look at, was there an event? I know I've had matters where a child was disinherited after being in a previous document, but there was a fight. There was an issue. So there was some kind of tiff or something that then led this person to go and disinherit that child. And so that's something that we do take into consideration with adult children. I will say in Arizona, you are not allowed to disinherit minor children. So If you're mad at your 16-year-old, you are not allowed to leave them out of your will. You are not allowed to disinherit your minors. And then that can kind of be a tricky thing where, if you have a troubled teen or something like that, I have seen people try to do it. It's not enforceable because it directly clashes with the statutes in Arizona. And that's why it's really important to go to a licensed attorney, estate planner to do your documents, because this is something I've seen document preparers do where they won't ask how old the child is, they'll just disinherit them. Whereas an attorney would ask the age and would dig in deeper and say, hey, you can't legally, you can't do that. I'm not putting that in here. But there are specific requirements of who can contest a will, but again, that's something that gets covered during the consultation with my attorneys. Again, there's a variety of factors that go into it where does it make sense to even bring this forward, or is this just more of us kind of giving them the conversation of it sucks, I'm sorry, but y- y- the chance of success here is so low. And the financial and emotional turmoil you would put yourself through is not worth it, in our opinion. Now, they can take that information and do what they want with it, but I would say that's more common than, hey, let's get you engaged and let's start this process.
Absolutely. What surprises some people is that creditors with valid claims can actually have a say in wills that are being contested. So how can this complicate things for the actual heirs?
So it's not so much that creditors can contest wills. They can file any creditor claim into the open probate that says, hey, this person owed me money. Now, where we get into a sticky situation is where a will, let's just use an example that somebody only has a house here. They had one kid, they have a house, they chose to do a will, and so it has to get probated because it's over the limits to do basically a small estate affidavit. And a creditor is owed money. Well, part of the probate process, one of the steps is to pay creditors. So that child, if there is an estate asset, and let's say the child tries to just transfer the house straight to them and then say there's no money in the estate, that's where a creditor would come in and say, hey, no, there was an asset, like you're required to pay the debts out of the estate assets. There was one. So I'm not so much contesting the will, I'm contesting the administration because I have a valid claim.
You've noted in the past that a person might lack the capacity to manage a checkbook, but still have the testamentary capacity to sign a will. How can you prove that distinction in a Mesa or Phoenix courtroom?
Very difficult. Capacity is like I said, it's a very fluid thing. It's day to day, it's hour to hour. And so we look at, before this person did any changes, did they have a doctor write a letter that said they could make legal decisions? Is there a neurologist involved? Do we already have some kind of diagnosis that would make us you know, look more into it of, hey, not every diagnosis precludes making new documents, but it definitely affects it based on severity, where they're at in the cycle. So that's again, unfortunately, where it kind of comes to the attorney looking at it and kind of seeing. I know we've had many cases where on the surface you've looked at it and it's very logical, like, no, this person did not have capacity. But trying to get the medical records to prove it, potentially having a doctor testify if they were closely monitoring them. That's kind of where that starts to come in, and where we potentially do subpoenas for medical records. We do depositions of doctors, that kind of stuff to try to really drill down. Did this person truly have capacity? But it is very much an uphill battle here in Arizona. It's a tough thing, because it is so fluid, because it's so day to day. So if they didn't see a doctor on that day, there's an argument to be made both ways.
Yes, indeed. And, here's another situation in Arizona. A lot of people retire to Arizona, meaning that their families are not in Arizona, and this can lead to isolation, and sudden changes to a will can often go hand in hand with that. So, what are the specific badges of undue influences that Arizona judges will look for when a new caregiver is suddenly named as a primary heir?
So we do have a case here in Arizona, and of course, I was so ready, and I'm blanking on the name, but it literally sets out the requirements for an undue influence claim. I believe it's 7 or 8 kind of metrics. A couple of them are, were they in a confidential relationship? Confidential relationship is somebody that has intimate knowledge and access. So a spouse is automatically deemed to have a confidential relationship, a child, a medical provider, could be an attorney. Those are all confidential relationships. But does it really apply under the statute? We've had cases where, somebody had a friend help them, and that friend was a licensed attorney, but they weren't licensed here. And the court actually ruled there was not a confidential relationship between the two of them because that's not how they were acting. So that's one of the key things that we kind of look at is what was the relationship, to your point? Is this a neighbor? Caregivers have a confidential relationship because they're managing medication, they're managing care. The other thing we look at is, did the change make them a like primary beneficiary? So, for example, did this person say, look, my family's far away, my neighbor helped me with groceries, taking care of my dog, driving me around. I gave them 5%, or I gave them $10,000 when I died as a thank you, versus they got my whole house and now my kids are all disinherited. So that's what we look at as well, is what was provided, is the relationship kind of congruent to the, let's call it a reward, even though that's probably not the best word for it. Those are kind of the two things we focus on. Um, we do look at, capacity. That's part of it, which is the ability to make these changes. Again, I've seen people that were in memory care facilities and people took them out of the memory care facility, took them to an attorney and brought them back. So those are really kind of the 3 out of the 7 to 8 that are kind of the higher ones that we look at first. And, then the attorney kind of will trickle down into the other ones. Not to get too deep into it, but there is a way, basically, whomever is contesting the will or the trust has to prove those elements. It's on them to prove it. Arizona law presumes that the document's valid till it's not. There is a place though where they can prove so much that it switches the burden of proof, and then the person who has the document has to defend. I have not seen the burden shift on any of my cases. It got close, but it does happen. So again, that's something that we look at as well if somebody approaches our office for this, because we kind of tell them, hey, this is a potentiality. If this does happen, is this something we have evidence to defend? Because we kind of have to be ready for anything when we get into these.
Let's talk, Carly, about the no contest clause. Some people think it makes a will bulletproof. What can you tell us about that?
This is probably the biggest question I get, and why people are very hesitant when they call to not even schedule. The no contest clauses that we see in wills and trusts that's, say to the effect, if anybody challenges this, they're disinherited. That no contest clause does not protect bad acts or illegal behavior. So if this will was procured fraudulently, let's say they forged the person who passed away's signature, that no contest clause does not come into play because it's a fake there was some kind of act. No contest clauses are to protect what we kind of talked about previously of, I don't like the content, so I'm going to fight the will. You don't really have a reason to fight the will. You just don't like what it says. That's not a reason. So that's where the no contest clause would kick in. It doesn't have anything to do with if there's actually some kind of fraudulent issue or this will wasn't done right, it's not valid. So you're not going to be disinherited for saying, hey, something's fishy here, and you have a reason. Even if you lose, if there was enough reason to bring it forward ethically, and then we find out, okay, that no contest clause still does not disinherit you. And so I found a lot of people have a lot of fear associated with that. They're scared to even talk to us. I've had many people say, you're not going to call them, right? No, your consult is protected under attorney-client privilege. We don't reach out to people till you're engaged and we've had a conversation. So I would encourage people that you can seek information. Those no contest clauses are just to protect from basically a frivolous suit of one sibling saying, well, mom loved me best. Why is it getting split 4 ways? I want it all. That's not a reasonable contest. So that's what that protects against.
Okay. Well, I know we've talked several times about how use paralegals actually in your organization as the first line of, I hate to say, but defense, sort of, that your first line in managing family emotions. So, how does your firm structure as an alternative business structure improve a client's experience during a heated will contest?
Anytime we have any kind of contesting going on, it's an expensive file. Litigation's expensive. The cheap litigation files we have are 30 to 50 grand total. I've seen them go over 100. The sky's the limit when everybody's got their feelings out. And there's other factors that I think I covered in another episode of how it can make it more expensive. But by trickling down the work to the person that can do it ethically, we keep bills under control. The
That's
attorney does not need to sit on the phone and listen to you complain about how it's not fair, your brother or sister sucked, they were mean, like, why did mom do this? It matters. It matters to the case. It's very important. The emotional part of what we do is important, but you don't need to pay the attorney to listen to that. That's something I can listen to, or April will assist me sometimes, and then we can kind of relay the overarching theme to the attorney. Like, hey, they're really upset about this piece of personal property. And maybe that was a 20-minute rant, but I just gave the attorney the information they need to keep moving the matter forward, and they didn't need to get into all that. So it's important that our clients are heard and that they feel supported. And that's just the emotions just go with the territory of what we do in this practice area.
And just briefly, as we wrap up this episode, when a will contest threatens to drain an entire estate's value, like you just indicated, it can happen. How do you use mediation to protect family assets from being consumed by those legal fees?
So if we look like we are close-ish, like there's some common ground, we will do either a private mediation where we pay another attorney or a retired judge to come in, basically look at the case, and then pretend to be the judge. Like, if I was the judge and this went to trial, here's what I think would happen. I think you would lose. I think you would win, vice versa, whatever. I think it'd be a deadlock, whatever. It's close. And so they can kind of help push each side. Sometimes we will have a settlement conference in front of an actual sitting judge in probate court. They'll block a half a day for us, and the wonderful world of COVID brought us virtual, so they will put us in basically virtual rooms. And the judge will bounce, or the attorney will bounce back and forth and kind of say, hey, I'm seeing this, I'm seeing this. You're able to talk more freely. And so if we can get to a settlement, that's what's best for everybody,
Absolutely.
because we can just get it done, lock it down, close it up, and then everybody can stop spending money. Everybody can stop fighting. Everybody can stop with the, heightened emotions, and we can just get things taken care of.
Well, that is it for today's episode of Probate Problems and Practical Solutions with Carly Whiteside of Copper Ren Law. To learn more about how Carly and her team support Arizona families through probate, guardianship, and trust administration, visit copperrenlaw.com. Thank you for listening, and remember to leave a review, and subscribe to the show so you catch every episode. Thank you, Carly.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.